Papers, reports from committees, notices of motions given orally, questions and answers to questions.
Mr. President. Thank you, Mr. President. Mr. President, I shall...
Morning, Senator Fraser-Binns.
Morning, Mr. President. How are you? Mr. President, I shall wish to inquire as to when I may receive answers to the questions standing in my name.
Leader. They were addressed to Senator Reid. Senator Reid, yeah.
Mr. President, questions that were posed and the answers are being worked on. I hope in the shortest possible time to have them tabled.
Could you explain shortest possible time, please?
Mr. President, I'm aware of the draft answers to those questions, and so they are in the review process, so they will be available, as I reiterate, in the shortest possible time, Mr. President.
Senator Fraser-Binns, is satisfied with that?
Mr. President, I'm not quite sure how I can measure shortest possible time.
No, I got the Senator, when he started, indicated that he had seen a draft of the answer, so presumably...
So perhaps we can agree to 2 weeks from today then, Mr. President?
Absolutely. Thank you very much.
Very well. Thank you.
Thank you, Senator Fraser-Binns. Motions that may be made at the commencement of public business requiring notice. Motions relating to the sittings of the Senate. Motions for leave to introduce bills. Senator Reid, please. The presentation of bills without leave of the Senate first obtained. Public business.
Mr. President, it is with a renewed sense of purpose this morning that I rise to once more seek to complete the debate, to conclude the debate on the companion bills which address pension reform. It is intended that that will be the primary, the main business of the day, and the motion in respect of the National Irrigation Commission will be the other item taken. It is not anticipated that we will address the agricultural bill today, as they are still working on one or two of the more complex issues that arose out of the debate. So, Mr. President, in closing, I wish to reassert, and I'm quite sure that the commitment is shared on both sides, and that is the commitment to public sector pension reform. And commensurate with that commitment to public sector pension reform, I want to also reiterate a commitment to collaboration, to a cooperative approach. And this, I believe, has clearly been reflected in the various attempts to suspend debates and to continue discussions where clarification, to address matters where clarification was needed. In the most recent instance, of course, the debate was suspended at our sitting on September 1st. And subsequent to that, on September 15th, the Honourable Ministers Shaw, Williams, and Spencer met with representatives of the trade unions, of the Joint Confederation of Trade Unions, and the concerns of members were heard and matters were discussed with a view to taking this issue forward in concrete ways. Of particular importance to note, as these issues were raised in the debate, it's been agreed, and the government has given its commitment, that the matters of portability, indexation, and vesting will be addressed in the first statutory review of the bill. So these matters, the importance of them has been acknowledged, but it has been recognized that they cannot be addressed in this particular bill, and they will be further on in the statutory process. I think it should also be noted that many of the concerns which were raised were not new. And I think there's a broad understanding as well that the matters all do not address the bill themselves, but are matters which may have to be addressed in the broader process of public sector reform, or for that matter, in the regulations when those are finalized. To address the matter of regulations as well, because this has come up as an issue, and in particular, concerns were raised about amendments to the judicial service, police service, and public service regulations, which were introduced by way of the third schedule to the bill and set out in the list of amendments that had been circulated. I stated it then, but I want to reaffirm that the amendments that are being made there are consequential because those regulations were made under the Constitution. They cannot simply be changed in the regulations as had been proposed. So they have been introduced as the consequential amendments and not the substantive amendments have been introduced under Schedule 3 of the bill before us to allow for their proper introduction and to allow for the smooth understanding and interpretation and operation of the regulations in that transition period when the new law comes into effect. So matters which have been addressed in those consequential amendments address the language. So it addressed the name of the Pension Act under which the regulations will now operate. They amended the retirement ages because those, of course, are changing by virtue of the bills before us today. They delete references to non-pensionable posts because, of course, with the passing of the legislation, there will be no non-pensionable posts per se. And similarly, in respect of the matters relating to receiving pension on termination, because in those circumstances now, you will receive your payment under the Employment Termination and Redundancy Payment Act, not as a result of the abolition of a post, etc. Those are being addressed in the regulations. These are not matters which substantively change those regulations. I want to also clarify that I made an error indicating that an amendment was being made to Clause 49. The amendment is to Clause 50 of the bill. And it's a simple amendment. It's just changing 2018 to 2019 because of the timing, the delay that really has occurred in the implementation of this bill. And therefore, I don't imagine that will cause any challenges. Mr. President, I'm confident that today, colleagues on both sides, and in fact, all stakeholders that have been a part of this process and that will continue to be a part of this process, acknowledge that the bills before us today are the first step, the first concrete step in public sector pension reform, that we have to address a situation which is way overdue. The affordability of pensions, the affordability of public sector pensions is a matter of grave concern, and with it, not only the well-being of our economy, but clearly the well-being of our workers. And I want to make the point that it's not only public sector workers that are affected, but private sector workers too, because guess what? All of us contribute revenues to the consolidated fund, which is from which the majority of pensions are paid. As they become more unaffordable, the strain on the economy becomes greater. And as I gave the figures at the last sitting, and others have shared as well, this matter is impatient of debate. And I look forward to the cooperation of all members as we proceed now to committee so that we can take the bills through their final and concluding stages. Mr. President, I thank you.
Mr. President, before we go to committee, there was one matter on which I would invite the comment of the leader of government business. At the last sitting when we were debating this bill, based on advice that the minister had received from the technical staff there, a statement was made to the Senate that the regulations had been shared with the with the president of the Jamaica Civil Service Association on behalf of the Joint Confederation of Trade Unions. That statement precipitated some correspondence on which I was copied, in which the president refuted that, the accuracy of that, and in particular made it clear that the terms upon which the draft regulations were handed to him were explicit, that it was on a confidential basis, and that essentially an undertaking was extracted from him, either impliedly or expressly, not to share it at all because of the confidentiality of the draft regulations. So he understandably was upset that this was being said in the Senate, it being not the case that he was given it on behalf of the joint, Jamaica Confederation of Trade Unions, and he had invited the leader of government business, who was copied on the correspondence, to clarify the matter in the Senate, and I would invite her to do so.
Minister, you are aware of what the leader is talking about?
Yes, Mr. President.
Okay,
I'm aware of the matter. I'm not aware of the correspondence, and that may simply be a function of the fact that I've been overseas for a significant period of time. But it is not a matter which I would contest. The advice that I received was not, there seemed to be a lack of clarity in terms of the terms on which the draft was handed over. I am aware, however, that subsequent to the sitting, the draft has formally been shared. I believe it was on the cover letter September 20th, in openness and for all actions and reviews which they would wish. But I also know that when it had been shared, it was an opportunity for their private consultations, etc., which I presume had commenced, given that there was reference to legal consultant, etc. But the issue is not one which is contentious, Mr. President. The draft regulations have been shared, but the fundamental issue is really the point which was, so perhaps I should make clear that I regret if there was any discomfort caused by that. If there was lack of clarity in the guidance I received and lack of clarity in what I stated, then, I regret the discomfort caused. But certainly the fundamental point which had introduced that whole issue was the fact that the regulations which were being brought here under the third schedule were not regulations that were substantively changing matters which would be within the awareness of the trade unions, which is that the substantive terms of the regulations, those three regulations which I referred to earlier, they are not being changed. It's consequential amendments that address the language that changes as a function of this bill. So again, regrets for discomfort caused, Mr. President, and I do hope that the discussions which have been held in my absence, the meetings and correspondence that had been exchanged, have ensured that the collaborative spirit of partnership in which the discussions had been commenced has been reestablished and reasserted, and we're all now moving together to ensure that we have, as best as possible, substantive and effective public sector pension reform.
Thank you, Minister. Are you moving for the second reading of both bills?
Mr. President, I ask that both bills be read a second time. Thank you.
I'm going to take, first of all, the Pensions Public Service Act 2017. And the question is that the Senate resolve itself into a committee of... I'm sorry. Well, perhaps you could just do the second one at the same time. So the question is that both bills be read for a second time. Those in favor?
A bill entitled An Act to Establish a Contributory Pension Scheme for the Public Service to be known as the Public Service Pension Scheme, from which payment of pensions, gratuities, and other allowances are to be paid in respect of the service of pensionable officers, and to provide for other related matters, read a second time. A bill entitled An Act to Amend the Constitution of Jamaica to provide for circumstances in which pensions, gratuities, and other allowances may be paid out of a fund established by law other than the Consolidated Fund. Read a second time.
The Senate will now resolve itself into a committee of the whole Senate to consider both bills clause by clause, dealing first with the Pensions Public Service Act 2017. You have a list of amendments. Okay, so I will put
And just to confirm that we're all working with the September 1 list of amendments. That was the last one circulated.
Mr. President, Chairman, if they have changes to this August 25th draft, which I assume there are, otherwise there wouldn't be an updated draft, it would be helpful to have the draft that we're working from.
July 28th.
It's dated August 25th at the top. Is that the same document?
July 28th. Do for all of us. All of us.
Well, none of us have it, so I don't know.
We don't have it. No, it wasn't table. No. July 28th.
It may be the same. I'm just looking at the pagination, and it looks. I'm not sure. Okay. Yeah, no, it's not the same. It's not the same. But this is a tract. What I have here is a tract document, with tract changes. This is what he just handed me, That's what was tabled, the document. Oh. Right. Okay, well, that's what I've just been handed by the orderly. Or is that his, yeah, that is a tract document, but it's got tract changes like this. It's a tract, and so yeah, that's it. So there's not a clean version of it. Yeah, we'll work with that. Yes.
Thank you very much. So
a tract document is where
I put clause 1
amendment is underlined. If this was in color, it would be in red. So
of the bill, clause 1. Those in favor?
Aye.
Against? Ayes have it.
It's not many.
I put clause 2 of the bill.
No.
Those in favor?
Mr. President, clause 2, there are amendments to clause 2. They are numbered 1 to 5, pages 1 to 2 of the list of amendments.
Is that on the sheet?
Yes, Mr. President.
Okay, so I will put the amendments as noted.
You don't have this?
Aye.
Yeah.
Those in favor?
This hasn't changed.
Against?
August 25th.
Ayes have it. I put clause...
One second, Mr. Chairman, I'm sorry. What do you have?
July 28th.
Huh?
July 28th.
Yeah. It would be helpful if there are any other printed copies of the amendment sheet. We would like to have them because
Sure, but just
I
to
am the only
confirm
person
that
who
they
has
were
it.
circulated and
Is somebody looking about the photocopies of the copies are being made? Okay, so what I'm going to do is suspend the sitting for 5 minutes until the copies are
That would be
presented.
helpful. Unless you want to take the other bill, which I don't, there are no amendments to the other one. Yeah. Yeah, but I'm saying if you didn't want to waste the 5 minutes, we could do the other one, but it's up to you.
All right, I'm going to suspend for 5 minutes.
Minister, please come with us, sir.
Breaking news. A senior politician and senior civil servant have been charged for corruption.
Thank God not all of them stay so.
Build integrity. One law for all.
A message from NIA.
Jamaica.
We can do so much as individuals.
But together, we are forced to be reckoned with.
The world loves us. They love our music, our good body culture,
our athletes, our lifestyle.
But have we been loving ourselves and each other?
We have lost over 100 of our brothers and sisters since the start of 2017.
And we recorded a total of 68 murders by domestic violence alone in 2016.
Do we really love each other? Do we really know what love is?
Love is freedom.
Love is kind.
Love is care.
Love is acceptance.
Love doesn't hurt.
Love is having the courage to walk away.
If I say I love you and you say you love me,
there's no way we can hate. This love is coming straight from my heart to your heart and your conscience.
No violence in love.
They will come when they will try to escape, when there will be nowhere to run.
No one is above the law. We encourage all Jamaicans to join the fight against corruption, organized criminality, these nefarious activities that stymies our country's progress. I want to encourage all Jamaicans to call. We have a secure line, 1-800-CORRUPT. Call anytime and we will treat the information received with the highest standard of confidentiality. We need your help. We want to elicit your support.
Call 1-800-CORRUPT. That's 1-800-267-7878. Be the change. Report corruption today.
Hi, I'm Christelle Tomlinson, and I endorse WMW's How Her House campaign.
Hi, I'm Javion Nelson, and I believe women have contributed to all areas of Jamaica's development. And so, there is no doubt that they are all powerhouses.
And so, as women, we have to understand and recognize and own that we are powerhouses. I am a powerhouse. You are a powerhouse.
If you have information about illegal guns, call 311. Get the Guns, an initiative of the Jamaica Constabulary Force.
As an inner city youth, I'm beautiful, know my rights. Not because you see me on the corner, you are going to abuse me.
I have a life to live. I deserve to be heard and respected. But know my rights. Know your laws. Know your rights. Respect you.
A living icon, Jimmy Cliff is a multi-award-winning reggae artist.
I can see clearly now, the rain is gone.
Actor and cultural ambassador. Jimmy Cliff has been praised for carrying Jamaican music to the world. In 2010, he was inducted into the Rock and Roll Hall of Fame. He is also the only living musician to hold the Order of Merit, the nation's highest honor for his tremendous contributions to the arts and sciences.
Many rivers to cross, but I can't seem to find my way over.
There's a long-distance relay that's still on. Many have taken it this far, each leg as important as the next, each challenge faced with determination. Now it's your turn to take the baton. People living with HIV and AIDS and those who are vulnerable need your commitment. It stands in the way of a better quality of life for all of us and our self-respect as a region. It stands in the way of victory in the fight to stop the spread of HIV. Reject stigma and discrimination. Get us to zero.
Against? Ayes have it. Clause 3 of the bill. Minister?
Amendments to Clause 3, Mr. President, are also set out in the list of amendments. They're to be found on page 2, and they are numbered 1 and 2.
Thank you. Can I have, I put the amendment to Clause 3 contained on page 2. Those in favor? Against? Ayes have it. I put Clause 3 as amended. Those in favor? Against? Ayes have it. I put Clause 4 of the bill.
Mr. President, Clause 4 is amended as set out on the list as well. It is to be found at the end of page 2, going on to page 3 of the list of amendments.
I put the amendment to Clause 4. Those in favor? Against? The ayes have it. I put Clause 4 as amended. Those in favor? Against? The ayes have it. I put Clause 5 of the bill.
So, Chairman, there's no amendment to Clause 5.
Thank you. I put Clause 5 of the bill. Those in favor? Against? Ayes have it. I put Clause 6 of the bill.
Mr. Chairman, Clause 6 is amended as set out towards the top of page 3, and it is amended to align the closing words of subsection 2 with Clause 7 in respect of a suggestion that had been made by Senator Golding.
Thank you very much. I put the amendment to Clause number 6 contained on page 3. Those in favor? Against? Ayes have it. I put Clause 6 as amended. Those in favor? Against? Ayes have it. I put Clause 7.
Mr. President, Clause 7 is amended as found on page 3. There's a small typo that can be noted in the word establishment in subclause with subclause 4, but that is, of course, editorial.
Okay. The removal of the dash or hyphen So
this clause 7, if I may, the new subsection 4, and this is a very important matter. It's dealing with the establishment of the fund, which is the segregated fund into which contributions are to be paid separate and apart from the consolidated fund, which is really what makes this a more orthodox pension fund. And the new 4 provides for the date on which the fund is to be established. And the mechanism is now that the minister has to be satisfied, having consulted with the Auditor General, that setting up the fund and bringing it into operation will not result in non-compliance with any of the requirements specified in Section 48C of the Financial Administration and Audit Act, which is the provision in our law that deals with the fiscal rules, or some aspects of the fiscal rules, fiscal targets in particular, it says here. I have no difficulty with that provision. What I'm questioning is why we need subsection 5, which goes on to say, notwithstanding what I just read, the fund shall not be established until the minister is satisfied that the debt to GDP ratio has achieved 60%. I don't understand why we're putting that in the law, that until the debt to GDP ratio has achieved 60%, we won't set up the fund, because I would have thought that compliance with the fiscal rules is a sufficient requirement as a condition of setting up the fund, but the actual timing of when you set it up could be left to the minister to determine, as long as the establishment will not result in non-compliance with the fiscal rule. If setting it up is going to put us in breach of the fiscal rule, whatever the prevailing target is, currently 7%, a primary surplus target of 7% of GDP, and there are some other aspects to it as well. If the setting up of the fund would breach that, then one has to wait until one is in a position as government to do it. But provided that it can be done without breaching that rule, I don't know why we're fixing in the law that it cannot be set up until the debt to GDP ratio is 60%. The magic of that 60% is questionable. It's a target in the fiscal rule that we are going to try and get to that situation by, I think, 2025, 26 fiscal year. But I don't see why we're doubling up on this requirement. So I'm asking, and presumably this was not something that came from the House of Representatives. This is something which is being amended now. So
it actually, I was just waiting for you to finish, Senator.
Yeah. Well, I'm interested to see what is the reason for this, why we're choosing to do it.
Well, it actually has come from the House of Representatives. It is in the bill. The only difference is that it has been taken out of 4, and meaning clause 4 has now been bifurcated. It's been separated into 4 and 5, removing the reference to the debt to GDP target from 4, where it is in the bill, as printed and as passed in the lower house, and just placing its own subclause, so that the verification in respect of consultation with the Auditor General, etc., is really about the non-compliance, addresses the matter of non-compliance, while the minister's satisfaction that the debt to GDP ratio has been reached, which was set out again in clause 4 as amended by the House of Representatives. So it's simply been moved, and that matter was debated.
All right, I accept that it was inserted in the provision that was in the bill before, and I'm happy that these provisions are being redrafted, because in the form in which they were inserted in the House, they were extremely difficult to decipher. But I'm still questioning why this requirement is being imposed. If we can set up the pension fund and start to fund it with contributions, and the Auditor General can certify that doing so will not breach the fiscal rules and will not result in non-compliance with Section 48C, why is it that we're in addition saying that we can't start the fund until our debt to GDP ratio has reached 60%. You know, I don't see why.
Senator Golden, that is the question that you're asking, so could I have a response?
It may be belts and braces, admittedly, but it is the position that has been agreed as a way forward. I am aware that in discussions, the fact is that the government is hoping that we will actually be in a position to be able to set up the fund even earlier than that. But it is a function of the broader circumstances, and the policy position has been taken that we will that both circumstances, as have been identified as relevant in the House of Representatives, will be taken into consideration before the fund is established.
Mr. Chairman, that response is confusing to me, because if it is hoped that you will be able to do it sooner, then why are you putting a provision in here that says you can't do it sooner? You know, and the fundamental issue, I think, is the ability to continue on the pathway of debt reduction, which is what the fiscal rule is designed to ensure. The actual achievement of a 60% debt to GDP ratio is somewhat incidental in this regard. And more importantly, I think, is that we start to take the pension liability off of the consolidated fund and start to put it in a segregated fund and have it funded by contributions, and deferring that if we're able to do it sooner without breaching the fiscal rules doesn't seem to me to make sense. So I really think that I can understand this belt and braces concept, but I think it's actually not helpful here, and that subsection 4 should suffice without subsection 5.
Mr. President,
President, this has been a concern of the trade unions about the need for a segregated fund, and the sooner the better. I can't see why, if the debt to GDP ratio is 63, 61, the minister should be constrained in setting up the fund. And therefore I support the position of Senator Golden, and I believe that this would be the trade union's view as well, that the sooner we get to this fund, the better, while having regard for the fiscal rules. And I urge that we delete this amendment and stick with the one at the new 4 dealing with the fiscal rules, so that it doesn't restrict and constrain the minister in moving quickly to what everybody wants, a segregated fund.
Thank you, Senator Brown.
Sorry, if I may, one supplemental point which I think is relevant. The liabilities that are currently building up on the government to fund pensions in the future because of our current pension arrangements do not form part of the public debt number. But they are real and they are growing, which is why this legislation is so important. So this provision is saying until the public debt number gets to 60%, we can't start the segregated fund and start funding it with contributions, which is going to reduce the contingent liabilities, which are not part of the public debt number, but which are real and have to be faced. So in a sense, you're almost saying we're going to defer the date that we start to grapple with the need to manage those contingent liabilities and get them down or eliminate their accrual until the public debt number, which doesn't recognize those liabilities, has reached 60%. And I think the thinking, to my mind, is flawed, because it's not to say that until while we're in the process of going down to 60%, those other liabilities are in abeyance. Those liabilities are there and are growing. So the sooner we get the fund in place, the better, as long as we don't breach or negate or prejudice the pathway of debt reduction that we're on, as embodied in the fiscal rule.
Senator Golden, I get your point, and I think that the minister can respond and we move on. Senator Albin Hill, you want to say something?
Yes, President. I hear the concerns of wanting to get to the segregated fund as quickly as possible, and I share that concern. Right now, we're paying out of our consolidated funds on a system that really, every time you put somebody in a defined benefit, you are in fact signing a blank check. We're moving away from that to defined contribution where the government's risk is identified. However,
let him finish now, please. What is the point of order? It is not a point of order.
I didn't finish. Let me finish.
Senator Brown, that is not a point of order. Allow him to finish now. Go ahead, Senator Brown. Senator Hill, please.
Thank you.
Brown, you can respond when he's finished.
Thank you very much. I sat and I listened to you. We have all the ministry papers, and yes, fine. Let's address directly what Senator Mark Golding is talking about the 60% GDP. That 60% GDP, debt to GDP figure was pulled out of the air. And his desire to move to a place where we stay on the trajectory to reduce our debt is going to be so much more firm when we have a clear objective as to where we're going. Otherwise, when we get to 90, or we start borrowing again, the clear decision when we went into, when the government of the time, his party went into NDX, was that we're heading to 60%. And all we're saying is that's the objective we hope to have before we begin to take on other commitments that is going to derail us getting to that objective. The fact that the Auditor General will signify the other issues and that the 7% primary surplus, which we all agree is very, very high and exceptionally high, is going to be there is one point. But to now take away what the House put on in terms of the 60% target debt to GDP, which is critical to get us to a place where we operate like a normal country. To move that away for this, which is a very big liability we're looking at, is unwise. And the House moved in that direction, and I support it from this chamber.
Thank you very much. Thank you very much, Senator Hill. Thank you. You wanted to say something, Senator Brown?
I want to say one point on that, though.
Mr. Chairman,
I just want it to be absolute.
Sorry, yes.
Mr. Chairman, I just want to ask members, please, to recall that we're in committee stage now and we're not reopening the debate. And as much as, of course, we are facilitating members to air their issues fully, their concerns with the amendments, that we're not reopening the debate.
Senator Minister, with the greatest of respect,
provision in your amendments.
With the greatest of respect, I would not allow that in any event. So thanks for the guidance.
Mr. Chairman, I wanted, just for clarification, the 60% debt to GDP ratio is a target that is in our law, in the Fiscal Responsibility Framework, in the Financial Administration Audit Act. We will be running primary surpluses to achieve that, and nobody is questioning that. I'm not questioning that. That is indeed where we want to get to. However, my question is, while we wait to set up this pension fund as a segregated fund funded by contributions, we are building up contingent liabilities which are not part of the debt to GDP ratio. And the sooner we establish the fund, the better. And to my mind, if we can do so with the Auditor General having certified that it will not derail the pathway of getting to 60% of GDP as our debt to GDP ratio, it will not derail our ability to achieve our primary surplus target, which is the mechanism for getting there. I don't see why we have to put into this pension law that we cannot establish the fund until we get to 60% of GDP.
Senator Golding.
In other words,
hold on, Senator Golding, with the greatest of respect, this is the fourth time you have said that, you know, and even me understand it. Right?
I just want to make sure that you did. Mr. Chairman, I want to make sure that you did. Now that you understand it, I shall rest.
Thank you, Mr. Chairman. I think the point is that the target is a proxy which is internationally recognized as an indicator for stability. We plan to grow the economy. We plan to not only use debt and contingent liabilities as a matter which will be considered. These are the two circumstances which we think will be sufficiently and robustly indicative of the fact that we are in a position to have the funding to establish this segregated fund. And that is why it is being moved as it is, Mr. Chairman.
Thank you very much. So I put the amendment to clause number 7. Those in favor? Against? The ayes have it. I put clause 7 as amended. Those in favor? Against? The ayes have it. I put clause 8.
There are no amendments to clause 8, Mr. Chairman.
I put clause 8. Those in favor? Aye. Against? Ayes have it. I put clause 9.
Mr. Chairman, there's a mere marginal note amendment to insert the word board. After the word board, the words in trust. I'm not sure if that's editorial.
In an event.
Set out here as a substantive amendment, so let's do it. Yeah.
I beg your pardon? Mr. Golden?
I think it's set out here as a substantive amendment, so we may as well do it.
I put the amendment to clause number 9, which is contained on page 3. I beg your pardon? Well, I'm instructed that marginal notes are not an amendment to the bill. So I put clause number 9. In favor? Against? The ayes have it.
Hold on a second. I want to clarify that. Currently, the marginal note is deficient. There's a proposed amendment to the marginal note in the amendment sheet. If we do not authorize that to be made here, on what basis can the marginal note be interfered with afterwards? And it's not fixing a typo. It is clarifying that the funds are held by the board in trust. It's a very important
It has been indicated and it will be noted by the technical persons in the same way that they will delete the hyphen that was incorrectly.
No, the
point is that it is an editorial. It will be treated as such, even though it has been noted here.
I think that is misguided. It is not editorial. This is a substantive change to the marginal note. This is not removing the hyphen in the middle of the word establishment.
The point is it should not have been here on the list. And it should as an amendment, and it will simply be noted by the technical people and be in the bill as printed. It will be in the list of amendments, which will have the editorial and substantive amendments which are on this list.
Thank you very much.
Chairman, are we being assured by the minister?
But I thought that that's what the minister was saying.
I just want to be clear that is what she says. Like you are.
So, yeah.
So I want clarity.
I never said I was slow, you know. So don't put me into that category. Don't draw me into your box, Senator Brown.
Mr. Chairman, the Law Revision Act authorizes amendments to be made.
Senator Golden, listen to what I'm saying. The clerk has indicated that in her assessment, it is an issue for the technical staff that will be dealt with as an editorial issue. So take the assurance of the minister and the clerk that it will be dealt with.
I just want to make one point for the benefit of the Senate and the clerk, which is that the Law Revision Act gives certain powers to the statute law commissioners to fix errors of this typographical errors, some errors that are clearly not altering the substantive meaning of legislation, and that is used regularly, perhaps not sufficiently, to fix things that occur in the passing of bills which are overlooked. However, changing the substantive meaning of a provision, including a marginal note, which is not part of the clause, but is a useful guide as to what the clause is seeking to achieve, is not, to my mind, is not a typographical matter. It is.
Senator Golden, yes, Senator Knight.
I just ask one question. What do we have to lose if we authorize it?
Yes, without it, who's authorizing it?
What do we have to lose?
Technical people can just go change substantive.
We don't lose anything.
So
but the
let's
fact
just-
is, it is noted already. It has been noted, as other editorial matters would be noted when they arise. The simple matter as to whether it's categorized as an amendment or a technical one.
Well,
You know,
it is because
You know, perhaps, sorry, Senator Knight, perhaps you're looking at an issue that would bear some examination further down the road. But my instructions are that it is an issue in relation to a marginal note which is dealt with and has been dealt with as an editorial matter. And we have agreed to the clause already anyway, so we will make note of it and move on. The ministers are sure that it will be taken care of. So I put now clause 10. Clause 10.
Mr. President, Mr. Chairman, there are no amendments to clause 10.
There be no amendments to clause number 10. I put clause 10 of the bill. Those in favor? Against? Ayes have it. I put clause 11.
Mr. President, the amendments proposed to clause 11 are noted at the end of page 3, moving on to page 4.
Mr. Chairman, I have one question on the amendment to clause 11.1. It says, as a contrib... Yes.
I'm getting some feedback from the technical staff, and I'd appreciate it if it's distracting me.
Yeah.
Not that I can't do more than one thing at a time.
But can you do it well? Yes. 11.1 says...
You're saying something
yes, sir.
about
I'm just going to read the provision quickly. As a contribution towards the pensions, gratuities, and other allowances provided for under this Act, there shall be deducted, and these are the words now that I'm asking for some clarity on, there shall be deducted from the salary of a pensionable officer and an officer employed in a pensionable office and paid into the fund. It's though I'm asking what is the difference between a pensionable officer, which is a defined term, and an officer employed in a pensionable office. Is there, if presumably there's a difference, I'm just asking what
Yes.
it is.
There is a difference. So
Yeah,
you
what is
could,
the
for
difference?
example, be a temporary member of staff acting, or you could be acting in a pensionable office, but you are not actually employed in that role. So this expands to address the potential to deal with the temporary staff as well as permanent employees.
But it says an officer employed in a pensionable office. That's the word used, employed.
You may be a temporary employee, but you're still employed.
Thank you very much. That's clear for you, Mr. Minister. Mr. Golden, Senator Golden. Yes, Senator Brown.
My concern at 11 is that we're amending at 11.2, deleting the words of 5% of such salary. I understand why, because we're going to be taking 2.5 in some cases. However, what will be left within this legislation is a figure as prescribed by the minister. And it should not, and such figure should not be more than 5%. And I'm proposing that amendment so that the new thing, as may be prescribed by the minister, by order published in the Gazette, must have a limit on it of not more than 5%, which allow him to do his 2.5 or whatever figure, but doesn't make a minister in a position to take more than 5% overall.
So that doesn't have to come to Parliament. He can prescribe that without Parliament's blessing. So we're delegating...
I think that is more of an observation than a proposed amendment, you know.
No, in all seriousness, that the limit, the prescribed amount cannot be more than 5%. Right now it gives an unlimited option.
Yeah, you delete 5 and
All right, thank you, Senator Brown. Minister, you have a response to that?
I think, let me just take some guidance on that. In principle, What you say is perfectly sound because already the commitment has been given that it will be phased in at lower amounts in order to facilitate the adjustment of persons who are currently contributing something or contributing less than, to adjust them to the 5%. So there's no intention to go beyond.
Right.
As to whether we would accept that amendment at this stage, though, let me just take some guidance on that. So if we could maybe move on to clause 12.
To achieve it, Mr. Chairman, if I may, it would be very simple. One could simply delete the word of and put not exceeding. Yeah. So it's a simple thing to do.
I'm going to return to clause 11. So I would take clause 12 now. There are some amendments on page 4. For clause 12, there are amendments on page 4, and I put the amendments to clause 12. Those in favor? I can't really hear, Those in favor? Against? Ayes have it. I put clause 12 as amended. Those in favor? Ayes have it. I put clause 13.
Mr. Chairman, we have no amendments for 13 and 14.
So I put clause 13. Those in favor? Yes, sir. Senator Brown. Mrs. Cook. No, I think that, I think constables cover everybody, including from top to bottom, Yeah, it does. The word constable
Island
does.
Special Constabulary Force was merged into the regular force, but there's rural police, so I think that's still cool. Yeah.
Sure, that they're all included. Yes.
Yeah, but one is district and one is regular, so.
Yes. Just to indicate that, well,
I think that's interpretation.
It's going to confuse the issue.
But it said it shall not.
I'll leave that. Yes, so the assurance is that they're included.
Yeah, you may know that.
So if we could have 13 and 14, Mr. Chairman.
I'm going to take 13. Those in favor? Against? Ayes have it. I put clause 14. Those in favor? Against? The ayes have it. There are amendments to clause 15 contained on page 4.
Yes, Mr. Chairman, minor amendments.
I put the amendments to clause 15. Those in favor? Against? The ayes have it. I put clause 15 as amended. Those in favor? Against? The ayes have it. I put clause 16. There are amendments on page 4. I put the amendments to clause 16. Those in favor? Against? The ayes have it. I put clause 16 as amended. Those in favor? Against? The ayes have it. There are amendments to clause 17 also on page 4.
And they proceed on to page 5.
Thank you very much. So I put the amendments to clause 17, which are on pages 4 and 5. Those in favor? Against? The ayes have it. I put clause, it's 17, correct? 17 as amended.
There's no amendment to, oh, yes.
Clause 17 as amended. Those in favor? Against? The ayes have it. I put clause 18.
Amendment at the top of page 5, Mr. Chairman.
I put the amendment to clause 18. Those in favor?
Just give us a second, because this is one that was inserted in the new document we just got.
Just making the language consistent in terms of his confirmation as a pensionable officer, rather than being confirmed in his post, because the whole concept of post is no longer going to be relevant.
Right, okay.
Thank you very much.
This is not changing any of the substantive or underlying elements in relation to probation or other matters.
This is saying that the period while he's on probation or she's on probation is pensionable service. If he's confirmed in his
If he's confirmed or she's confirmed, so there's no prejudice. It's really just preserving the period worked prior to the
Thank you very much, Minister. I put the amendment to clause 18. Those in favor? Against? I put clause 18 as amended. Those in favor? Against? Ayes have it.
Mr. Chairman, we actually have a proposed amendment for 11.2.
For what?
11.2. Remember, we had suspended to go back.
Let me just go on first.
No problem, Mr.
Okay,
Chairman.
so I put clause 19. Those in favor? Against? Ayes have it. I put clause 20. There are no amendments. Those in favor?
Aye.
Against? Ayes have it. I put 21. No amendments. Those in favor? Against? Ayes have it. I put clause 22. Those in favor? Against? Ayes have it. There are amendments to clause 23, which are contained on page 5. I put it's essentially changing in numerals. So I put the amendment to clause 23. Those in favor? Against? The ayes have it. I put clause 23 as amended. Those in favor? The ayes have it. I put clause 24. Those in favor? Against? The ayes have it. I put 25. Those in favor? Against? The ayes have it. I put clause 26. Those in favor? Against? The ayes have it. I put clause 27. Those in favor? Against? The ayes have it. There's amendment to clause 28, which I put. It's contained on page 5. Those in favor? Against? The ayes have it. I put clause 28 as amended. Those in favor? Against? The ayes have it. I put clause 29. Those in favor? Against? The ayes have it. I put clause 30. There are amendments to clause 30 contained on page 5. I put the amendments to clause 30. Those in favor? Against? The ayes have it. I put clause 30 as amended. Those in favor? Against? I put clause 31. Those in favor? Against? The ayes have it. I put clause 32. There are amendments to said clause on page number 5. So I put the amendments proposed to clause 32. Those in favor? Against? The ayes have it. I put clause 32 as amended. Those in favor? The ayes have it. I'm at clause number 33, which I put their amendments to clause 33 contained on page 5 and 6. So I put the amendments to clause 33. Those in favor? Against? The ayes have it. I put clause 33 as amended. Those in favor? I put clause 34. Those in favor? There are amendments, on page 6. I put the amendments to clause 34. Those in favor? Against? The ayes have it. I put clause 34 as amended. Those in favor? Thank you. There are amendments to clause 35 on page 6, and I put the amendments or amendment. Those in favor? Against? The ayes have it. I put clause 35 as amended. Those in favor? Thank you. There is an amendment to clause number 36, which is contained on page 6, and I put that amendment. Those in favor? Against? The ayes have it. I put clause 36 as amended. Those in favor?
Second, sir, I'm sorry.
Sorry.
In relation to clause 36, it makes reference to in accordance with the Status of Children's Act and removes the words by order of a competent court. I was just wondering if, for example, this...
so you want to recommit the amendment?
If you would.
Okay,
yes, please.
The question is that the amendment to clause number 36 be recommitted. Those in favor? Thank you very much, Senator Golden. Go ahead, please.
Thank you, Mr. Chairman. Just a question. If, for example, this child or this family had migrated to Jamaica or had been outside of Jamaica and had come here, and the issue of the status of that child was regularized in another jurisdiction through a process which involves the court, rather than through the Jamaican law, I was just wondering if that we ought not to have kept the words in accordance with the Status of Children's Act or otherwise by a competent court. It was just a thought that I had that we may, I don't know if the Status of Children's Act would cover situations which have been addressed through the law of another jurisdiction or not. It's a question that I'm posing.
My understanding, when I had raised this same query, not specifically to other jurisdictions, but in relation to the broader jurisdiction, was that the treatment of the issue under the Status of Children Act was sufficiently broad to address everything, and the concern was actually that the use of the order of the competent court might not actually allow for everything. So,
if the technical team are satisfied that the Status of Children's Act would address situations that have been regularized outside of our country.
Yes, it is broad enough. The language is broad enough. Thank you.
Thank you very much, Senator Golden and Minister, for your response. I put the amendment to clause 36. Those in favor? Against? I put the clause 36 as amended. Those in favor? Against? Ayes have it. I put clause 37, to which there are amendments on page 6, I'm sorry. So I put clause 37, the amendments there too. Those in favor? Against? Ayes have it. I put clause 37 as amended. Against? I'm sorry. Those in favor? Against? The ayes have it. 36, that's 37. I put clause 38, there are no amendments. Those in favor? Against? The ayes have it. I put clause 39, there are no amendments either. Say something on 39.
Thank you.
Very useful observation, Senator Brown. So, so I put clause 39 with the observation. I put clause 39. Those in favor? Against? The ayes have it. There are amendments to clause 40 on page 6. So I put the amendment to clause 40. Those in favor? Against? I put clause 40. That slipped me in. I put clause 41. There are amendments. It appears on page 6 going into page 7. So I put the amendments to clause, clause 41, yes. Those in favor? Against? The ayes have it. Thank you, Minister. I put the amendment to clause 42, which is contained on page 7. Those in favor? Against? The ayes have it. I put clause 42 as amended. Those in favor? Against? The ayes have it. There are amendments to clause 43, which are contained on page 7.
In relation to the drafting of the amendment to the new 43, all existing public officers and dependents and persons claiming through them shall, if upon such date as may be determined by the Minister by order published in Gazette, they were eligible to receive benefits under the provisions of the Pension, Civil Service, Family Benefits Act, as if that act had not been repealed. Shall, if upon they were eligible, right? Shall, yeah, to which they were entitled, yeah, benefits.
Well, you see,
It's just really, I think that it shall continue to be eligible to receive such benefits as if that act had not been repealed. It's just an awkward way of formulating the last piece of it. Yeah, just it's a stylistic point, really, and I don't want to make a big issue of it, but it seems to me that if there's shall, if certain things continue to be, shall continue to be eligible to receive benefits as if that act had not been repealed. Yeah, it's just you don't get to, it's not to the very end of a longish sentence that you get the object of the provision. It's I don't think it's ambiguous, but I think it could be more elegantly phrased so that the non-lawyer would be able to understand it easier.
So it's, it's definitely not a clause that's contentious. It's welcomed. It's just a matter of the phrasing. And I don't have a problem with the more elegant phrasing. Already there were a few extra words that have been taken out. So if we're to simply change the order of the closing.
I'll revisit 11 and 43. Okay, Senator Golin?
Thank you.
Okay, so I will take clause 44. There are no amendments apparently. In favor? Against? Ayes have it. Clause 47, there are no amendments. I'm sorry. 45. I'm running ahead of myself. 45. There are no amendments to 45. Those in favor?
Yeah, but it's double
Against?
sir, triple sir.
The ayes have it. I put clause 46. No amendments. Those in favor? Against? The ayes have it. There are amendments to clause 47. So I put the amendments to clause 47. Those in favor? Against? The ayes have it. I put clause 47 as amended. Those in favor? The ayes have it. I put clause 48. There are no amendments to 48. Those in favor? Against? The ayes have it. I put clause 49. There are no amendments. Those in favor? Against? The ayes have it. There are amendments to 50, which are contained on page 7. And I put the amendments to clause 50, or the amendment to clause 50. Those in favor? Against? The ayes have it. Let me deal with clause 11 and 43 before dealing with the schedules, please.
Yes, Mr. Chairman, if you can recommit 11.
So the question is that clause 11 be recommitted. Those in favor? Against? Minister?
Mr. Chairman, the proposed amendment to 11.2 is that in subsection 2 we delete the words of 5% of such salary and substitute therefore the words as may be prescribed by the minister by order published in the Gazette, which shall not be an amount which exceeds 5%.
Okay, thank you very much. So
why use less words when more can do?
Okay, thank you very much. So I'm going to put the amendment to the amendment of clause 11. Those in favor? Against? The ayes have it. So I put the amendment to clause 11. Those in favor? Against? The ayes have it. I put clause 11 as amended. Those in favor? The ayes have it. Madam.
Yes, Mr. Chairman. So the amended clause will now read, all existing public officers and their dependents and persons claiming through them shall, if upon such date as may be determined by the minister by order published in the Gazette, they were, that's if they, yes,
Just be
shall.
All existing public officers
No.
shall, if upon such date as may be determined by the minister by ordinance, yeah. If they.
Which is strange, but it works. Let me just read it through. It works, but it is odd.
Yeah, all right. It is
okay,
odd,
so
yeah.
all existing, Mr. Chairman, all existing public officers and their dependents and persons claiming through them shall, if upon such date as may be determined by the minister by order published in the Gazette, upon such date, if they were eligible to receive benefits, shall continue to be eligible to receive such benefits as if that act had not been repealed. So I think what they're it's just that it's so far removed.
There's two ifs. It's if upon that date they were eligible.
Right. Just put in another if.
I don't know if you need another if.
You do.
Shall, if
You
upon,
do.
no, look at it again.
No, no.
If,
All right,
shall,
all right,
if
all right.
upon that date they were eligible.
No, read it now.
Senator Golding, it's actually clear if inelegant as stated on the page. So as you had said, you weren't going to make a big issue of it.
I don't question it. I don't question it.
We understand the meaning of it. It's
Yeah.
just that it does seem inelegant, but it is clear. So I want to ask Mr. Chairman if you can put the amendment.
Well, if Senator Knight couldn't assist in bringing clarity to it, then it's not possible to bring clarity to it. So I will put the amendment
You'd have to redo the clause from
43.
scratch.
Those in favor? Against? The ayes have it. I put clause 43 as amended. Those in favor? Against? The ayes have it. Madam Minister, I put I put the first schedule. And there are amendments to the first schedule.
Chairman, and they're set out from pages 7 to 9.
Thank you. So I put the amendments to the first schedule. Those in favor? Against? The ayes have it. I put the second schedule. There are amendments.
The amendments are to be found from pages 9 proceeding to 10, and they amend both Part A and Part B of the schedule.
So I put the amendments to the second schedule. Those in favor? Against? The ayes have it. I put the third schedule. Put the third schedule.
1 second, please.
The age of 60 years ought to be called upon to retire. So you shall put the matter together with the lead member to the commission. And the commission shall recommend the government.
Are we saying, while Senator Knight is looking at that, are we saying here then that the provisions, for example, that...
What are you looking at, Senator Golden?
In the third schedule, where we are, there were, for example, where we are saying, for example, that in the amendment to the Constitution of Jamaica Public Service Regulations, where we say in the second schedule to that the appropriate authorized public officers hereby authorized to make appointments of persons temporarily or permanently and to employ daily paid and casual pay employees in accordance with the provisions of this schedule. This is on page
I'm not happy.
I'm trying to find it on the new sheet because I'm looking at the old sheet. All right. Yes, here it is. On the wow. Do you have any pages after page 12? Oh, because the one I don't. The copy I was given doesn't have it. We don't either. The copy that we were made ended at page 12. I was reading from the previous draft of the August the 25th draft on page 12. It was the Constitution of Jamaica Public Service, the Public Service Regulations, and it was to do with the second schedule. And I was just asking a question. And similarly, in Regulation 45, the same question arises, which is, are you saying that these provisions are not, there's no substantive change to the existing regulations? So, where we say the procedure in regard to the disciplinary control of weekly and daily paid staff and casual employees shall be as specified in the second schedule. That's what we are putting this, we're amending something and putting that in. Similarly, in the second schedule, the appropriate authorized public officers hereby authorized to make appointments of persons temporarily or permanently and to employ daily paid and casual employees in accordance with the provisions of this schedule. What are we doing here then?
I believe, again, this is a function of language, but I'm just waiting to be reminded of the language that was changed. It's not a substantive change.
Okay.
It's simply to make it consistent or workable in respect of this. But I'm waiting on the specific language from which it's being amended.
So there's one question, if you don't mind. It's this is really relates to the earlier schedule or the second schedule, and it's to do with the private equity, the way in which the private equity provision is worded here, where we were adding a paragraph H, which allows investment in private equity. Now it says, which is not listed, but has a lower limit of not more than 5% as an investment option. Are we talking about 5% of the equity in the entity or 5% of the fund? Yeah, it's a little ambiguous. Yeah. To 5, I think it was, and the second schedule. Well, I'm sorry, I don't have page 13, so I can't see what it is. No. Yeah, the previous one, it was paragraph 1, not preliminary, paragraph 1. Yeah, it's the text of the new paragraph 1. Yeah, we don't have page 13. Yeah. I think what happened was the copy I was handed didn't have it, so I don't know if, yeah. Okay. So everybody didn't have it.
Clarification on 45?
Yes.
For you? All right, so the language here now in 45, without amendment, Regulation 45 says, the procedure in regard to the disciplinary control of officers holding non-pensionable posts and of weekly and daily paid staff and casual employees shall be as specified in the second schedule. So what has happened is that we have deleted the reference to non-pensionable posts as said earlier. So it's just for consistency. Nothing else has been changed. Okay? I think that's a broader issue beyond the scope of this debate, and perhaps could be one of the matters that are discussed as we work forward in discussions between government and unions and stakeholders, rather than seek to amend it now. I think it takes us out of the scope that we are currently in, and what we are seeking to do is deal with the regulation amendments separately. What we have here are the consequential amendments that will allow the bill, the regulations to operate with the amendments to the bill. So let's, noting your issue.
Minister, you're taking instructions? Minister, we are on the third schedule. Are you making amendments to the amendment?
I'm clarifying, Mr. Chairman. I had said that I would clarify the reference to Regulation 45 as well as paragraph 1 on the second schedule. So I will just read that for you as well. It says the appropriate authorized officer is hereby authorized to make appointments of persons temporarily or permanently, A, to non-pensionable posts in a ministry or department, B, to weekly paid posts governed by the Provident Fund Act or otherwise, and to employ daily paid and casual employees in accordance with the provisions of this schedule. So again, all that has happened is that we have deleted the non-pensionable posts, the reference. No substantive change.
Thank you very much. So I put the amendments to the third schedule. Those in favor? Thank you. I put the amendment, I put the third schedule as amendment. No,
I was, sir, but...
Sorry.
But I was just wondering, why do we say the appropriate authorized officer is authorized to do so and so? Why not just the appropriate authorized officer me?
Perhaps when the broader regulations are being looked at for substantive issues.
Thank you very much. So I'll put the third schedule as amended.
No, sir. I need some assistance here. The Constitution of Jamaica, the Judicial Service Regulations, where is this giving the Chief Justice a new power to recommend the retirement of a judge in the public interest? And if so, how does that actually affect the constitutional tenure? Seems odd to me.
I'm not aware of any substantive change, so let me take some guidance on that point. It's not a...
Yeah. Hmm? Yeah.
That's the original?
21.
You're seeking a clarification on a matter?
But they said 50 for Joe. One difference is that the existing regulation triggers that. The trigger date for this possible report by the Chief Justice to the Commission was 50 years, and now it's being set at 60 years. So that is a substantive change. The existing regulation, well, this is the copy I have here. I'm assuming.
What is it saying, that the retirement age is 50?
No, it's not saying the retirement age is 50. It's just saying where it appears to the Chief Justice that a judicial officer has attained the age of 50 ought to be called on to retire from public service, then the Chief shall report the matter together with his reasons therefore to the Commission, and the Commission shall recommend whether or not the person ought to be called upon to retire. So that was that. I don't know. You're saying that date was changed in these regulations before?
I'm not going to say so definitively.
I don't think it was. Huh? It was?
As a clarification,
yeah.
As you're aware, there's an overall policy change to change the retirement age, and they are set out here in the schedule. The retirement age is starting at 60. The only change here in this provision is that instead of referring to Section 8 of the Pension Act, because the Pension Act will be repealed, is that it is now being made, reference is now being made to Section 21 of the Pensions Public Services Act, which is what is before us.
Yeah, thank you. I'm satisfied that it's not a change in the authority being given to the Chief Justice. Yeah. It's consistent with...
But I just want to just explain to you, though.
Thank you, Senator Knight.
The change from 50 to 60 years in relation to judges. Yeah, where does that... What is the thought behind that? Because this power used to exist once a judge had achieved 50, if and it occurred to the Chief Justice that there ought to be a recommendation for retirement. The Chief had that power to make that recommendation. We're now changing that to 60. Why?
I think it's been broadly recognized that the productive lives, of public servants, including our judges, and that's generally been recognized, is longer than 50. 50 is early in the way.
Before 60. Judges retire at 70.
Provision which, notwithstanding that judges retire at 70, if there was a reason why the Chief Justice might think the need to retire that person, they could refer it to the Commission.
I don't believe.
Minister, you have something to say before I put the third schedule finally?
Just one question.
Yes, the point is that judges do still go at 70, but the age was set out in the Pension Act, and that is being, so the reference has to change to bring it to this act.
Let me wonder aloud. The magistrate, parish judge.
Mm-hmm. This is premature retirement.
Yes, yeah. The magistrate is a judicial officer. Isn't that so?
He's a judge now, parish judge, under the Judiciary Act.
Right. Yeah. So he's a judicial officer.
Yeah.
And the age of retirement for the magistrate is 60.
Yeah. That hasn't changed.
That hasn't changed.
Yet.
So now, the magistrate would not be caught in this.
The parish judges are treated as civil servants. They're not treated in the same way for the purposes of the regulations.
I thought we amended
judicial
that.
Officers for disciplinary purposes.
I thought we amended.
Disciplinary purposes, but generally, for matters in relation to retirement, etc., they're treated as civil servants. And
well, no, they're no longer treated as civil servants because they've been brought under the Judiciary Act, and their emoluments are fixed by the the Independent Commission of the Judiciary. Well, they are now set under the Independent Commission of the Judiciary. That was done in 2015 in relation to their pay and benefits. That has been done, but I don't think the retirement age has been changed.
No.
But this is dealing with premature retirement. So what we're saying is that whereas the Chief Justice could invoke this provision previously to a judge, in relation to a judge who once had achieved 50, for whatever reason, perhaps there are reasons why one might want to do this. We're now saying that can't be done until the person reaches 60.
The judges for the superior.
Thank you very much. So I'm now going to put, sorry, Senator Knight.
Even though we're going to pass this, if just task the officers to have a look at this in the context of how we have discussed it.
That's an undertaking, Minister?
Yes.
Thank you very much. I put the third schedule. Those in favor? Against? Ayes have it. I put the title and enacting clause.
Before you do that, sir, could you just okay.
Fourth schedule. Please note.
This was a schedule.
Yes,
right.
I put the fourth schedule.
Yes, thank you. This was to ensure that persons who should be and are eligible to be in the to participate in the pension scheme were
Is this a new schedule or this is
yes, it's a new
okay?
schedule.
So this is a new schedule.
And the
okay.
references have been made in the list of amendments because it was actually deficient.
I'm informed you did get it, sir.
And just to indicate, in respect of the other matter, that parish court judges are not treated like judges of the Superior Court in all respects, because that would have required amendments to the Constitution, and those amendments were not undertaken. So it really is just in certain respects.
Thank you very much.
The judicial officers doesn't apply to parish judges, is the point you're making.
And no doubt you will continue this debate downstairs. Can I put this fourth schedule, please? Those in favor? Against?
Chairman, just for general, I don't want to link it to any specific provision. The district constables, there was a policy to cause them to be occupying pensionable posts. I understand it's clause 13. Are they covered under this?
If you have a look at the fourth amendment to clause 2, it actually specifies and includes registered service, which refers to teachers, and service as a constable or district constable. So it's roundly and clearly asserted.
So if we're differentiating there between constable and district constable, then why is it that in the provision that came later, where we were talking in relation to the point that was raised, clause 13, there's no distinction between constable and district constable there. And if you have one provision in the Act making that difference and another not, then I'm sure it would be interpreted as being. Yeah.
Because in the meantime, remember that the district constables they are called district constables, but in the law they are regarded as members of the rural police force and not of the JCF. And the rural police force being a different entity, if that is not captured, then there could be some ambiguity in the statute.
This was a point that was made earlier. But because what was merged with the Island Special Constabulary Force, the Blue Seam, was merged into the force, but the DC is still separate under the rural police.
Enacting clause in the meantime. I put the title and enacting clause. Those in favor? Against? The ayes have it. Minister, you are seeking clarification on a matter.
Senator Knight, Mr. Chairman. So there's work underway in terms of the treatment of district constables and their benefits, etc., across the board. So in light of the amendments that I shared with you earlier, directed you to in terms of 2, it's clear that the intention is here to have district constables be entitled to participate in the pension schemes. But this is a process. So simply the way they've been treated in the Act is how it is now intended to work. And that will continue to be a process. But there won't be a sort of wholesale inclusion of every reference. It's not intended that every reference to constable should include district constable. The separate references are in fact appropriate.
But does that mean, for example, in 13, where you're excluding the provision of, you're saying a number of provisions shall not apply to constables, but is it intended that they will apply to district constables? It could.
It's a part of the administrative process that's underway. So we can't change it here because the implications would be uncertain. These are our instructions to date.
That, with the greatest of respect, I think we have passed that, So I don't think the minister is going to recommit it. All right, thank you. So the question is that I do report the bill as having passed committee.
Chairman, I understand the point you're making about we've passed it. No. But having regard for the fact that it was raised, we got erroneous response because we were told that they were included in it, but now we're discovering that in at least 2 places that were made amendment, the term a constable or district constable and constable and district constables have been used. It is clear that the information we got was not correct. And it is in that light, because we're going to be asked now to pass the entire bill, that these issues are being raised. And so the clarity we see ought to be such that it satisfies us that
And I can assure you that they will not be left behind, because the provision that I had pointed Senator Knight to, the definition of public service, including service as a constable or district constable, and other provisions in the bill, make it clear that the intention is to include district constables, but the fact is that they are not being treated in all respects as constables. So how it has been set out reflects the current policy of the MNS, and we cannot make changes now and try and pick apart where else you might think that possibly they should be dealt with, because that's part of an administrative reform process of how district constables are treated generally. Here, we're quite clear that the bill includes them in the definition of the public service, so they will be entitled to participate. How that works cannot be addressed here and now.
Chairman, what worries me is that there is a move as part of the Ministry of National Security policy to transition some district constable into the regular constabulary. And what goes with that service prior to the transition into the constabulary force? And we want to make sure that this bill captures them.
What specific provision we are debating, because we have gone through, I am now putting the question that we report as having the bill pass committee stage.
Mr. Chairman, I've already indicated that we are not going to make any further amendment to clause 13 because it currently reflects, it the point which is being made, or the request which is being made, addresses a matter of policy within the Ministry of National Security, and is therefore not within the scope of this debate.
There was one other issue, Mr. Chairman. Yes, but you...
Minister, I understand what you're saying. It is quite clear that the intendment is there at the very least. I wonder if you could persuade your colleague, the Minister of National Security, to make a statement in the House as to the district constables, because they're the only ones who didn't fall. They have a provident fund arrangement and so on, and they've been promised for at least 20 years, to my certain knowledge, that they would be made pensionable. So if the Minister of National Security could be persuaded to make a statement in the lower house setting out clearly their position, I would be very pleased if you make that attempt.
Thank you for the suggestion, Senator Knight. I'll raise a concern to my colleague minister, and will, of course, I'm sure that he will apply his discretion to the appropriate way to communicate with the district constables, whether it is through statement or otherwise. Thank you.
Yeah, Mr. Chairman, before you make your report, there was one other issue which related to the second schedule, paragraph 8. In fact, it's two issues. One was to do with the private equity provision, where a new paragraph had been added to subparagraph 8.2, a new paragraph H, which allows investment in private equity. But then which is not listed, but it says, but has a lower limit of not more than 5% as an investment option. I don't know why we need the words as an investment option there, because the whole of this list is to do with the investment options that are available for this fund. So what was that intended to mean? Is that 5% of the equity in a particular entity, or 5% of the fund? The other point I wanted to mention in relation to 8.1, where it talks about the board shall make investments with financial institutions that are licensed by the Financial Services Commission Act. That's not correct. Well, we don't normally refer to entities under the Financial Services Act as financial institutions, but they're really securities dealers and insurance companies. But they're licensed under the Financial Services Commission Act. Yeah. They're not licensed by the Act. They're licensed by the Financial Services Commission. So we should either remove the word act or change the word by to under. Just as we said later in the same provision, deposits in deposit-taking institutions licensed under the Banking Services Act. Yeah.
Good call. Yeah, good call on the Financial Services Commission Act. That is an error. It should be licensed by the Financial Services Commission. Yes. So, in fact, Mr. Chairman, I'm going to ask for recommittal of Schedule 2 for us to make that amendment.
Question is that Schedule 2 be recommitted. Those in favor?
Aye.
Against?
So, in particular, I would like to recommit the amendment to paragraph 8 of Part B. And this is A1. It says an amendment to the amendment, indeed. The paragraph should read, Mr. Chairman, The board shall make investments with financial institutions that are licensed by the Financial Services Commission and place deposits in deposit-taking institutions licensed under the Banking Services Act.
Thank you very much, Minister.
More
I
than
suppose
welcome.
that Senator Golden, you realize that tenacity does pay after all.
That has been my experience in life, Mr. Chairman.
So I put the amendment to the amendment of... I put the amendment...
Yeah, one second, sir. Before you put that amendment, if we could just have the response on the paragraph H.
On the matter of private equity, it was in fact addressing a suggestion which you had made. And the question, and the intention, it's agreed that the words "as an investment option" are probably not necessary. In terms of clarifying whether the 5% is of the fund, I think that becomes clearer there. Is it, if we simply delete "as an investment option," or do you wish to put 5% of the fund, of the value of the fund? Because it was apparently your concept which they were seeking to translate.
Yes. I mean, when we say a lower limit of not more than 5%, what are we? If what we're trying to say is that not more than 5% of the fund can be invested in private equity. Yes.
Which is what
Why can't we just say private equity, if you want to say which is not listed, not exceeding in total 5% of the fund, or not exceeding the aggregate 5% of the fund? Yeah.
Of course.
Chairman. Senator Golding, where we're going with this, we're looking at pension funds being able to invest in in equity facilities. And I fear that if you put that 5% cap on it, you're going to limit what we've had over the years. We've had pension funds being forced to buy Jamaican paper that went in one direction. They became poorer. If we put this cap on, my fear is that you will not allow enough poor people to benefit from equities, which is really where you create wealth. So I wonder if you would, what do you think about that?
The limit wasn't my suggestion. I had simply said that this list was a bit circumscribing because it didn't include private equity. What we have is in F the ability to list in equities but that are listed on the stock exchange. So that's there already. What we're talking about is unlisted securities, which are illiquid instruments because they're not tradable. So I think some limit should be there.
So you control the risk of unlisted.
Right.
Can we say that? Because we don't want to make the mistake.
It does say it. Can we say that we're talking about unlisted securities?
Yes.
Yes, it says it.
It says it.
It says it. I'm just saying that it was a little unclear as to what the limit applied to. But now I understand what it's intended to apply to, which is not more than 5% of the fund should be invested in unlisted private equity. Perfect. So it's just to word that appropriately now, and just say private equity which is not listed, but not exceeding in the aggregate 5% of the fund. But not exceeding in the aggregate 5% of the fund. But it's not done on it's not a 5% on one occasion, and it's an aggregation. Yeah, of all private equity investments should not together exceed 5% of the fund. Yeah, so I think it should be pluralized to make that clear. Such investments. It's plural, yeah?
So you need to use your microphone. The hand side is quite...
My apologies,
You say investment, it sounds as if you're saying each private equity investment isn't to exceed 5%.
Well, the language of the paragraph says that the board may invest in.
Minister,
and it
you need
says the
to
board
read
shall
it.
make investment through. I'm not sure it's...
Minister, you need to read the
Yes.
Final wording.
So,
Into the
so
micro.
paragraph H is being, in subparagraph 2.2.
Yeah, but there's a difference, you see. What is saying, the opening words is saying what you can invest in, and there's a list of different asset classes, all right? And H is saying private equity that's not listed.
Yes.
But what we're adding is a proviso to say that investments in private equity shouldn't exceed 5% of the value of the fund.
I think that's fine. Because it's not speaking to individual investment. Private equity, and this is for Hansard now, not for Senator Golding, he's already agreed, which is not listed, comma. But such investment shall not exceed in aggregate 5% of the value of the fund.
Yes, it does say in aggregate.
If the word in aggregate.
It does say in aggregate, so it's fine.
Yes.
Thank you very much. So can I have an agreement to the amendments to the amendment of Schedule 2? Those in favor?
Aye.
Against? May I have Schedule 2 as amended? In favor? Against? Ayes have it. So I do report that this bill is having passed the committee stage with 62 amendments. Those in favor? Against? The ayes have it. I do report the bill as having passed committee stage with 62 amendments. We intend to take the other bit of legislation. So I'm not leaving the committee stage yet. So we have before us, unfortunately, my mic was on, that I would have fluffed it. We have before us the Constitution Amendment, Established Fund Payment Pensions Act 2017. And the clerk has read the bill for the second time, and we are in committee stage. So I put Clause 1 of the Act. Those in favor? Against? Ayes have it. I put Clause 2. Those in favor? Against? Ayes have it. I put Clause 3. Those in favor? Against? Ayes have it. I put the title and enacting clause. Those in favor? Against? The ayes have it. The question is that I do report the bill as having passed committee stage without amendment. Those in favor? Against? The ayes have it. I do report the bill as having passed committee stage. Yes. I do report the Pension Public Service Act as having passed committee stage with 62 amendments, and I do report the bill, the Constitution Amendment Establishment Fund Payment Pensions Act 2017 as having passed without amendment.
Mr. President, might the bills be read a third time?
The question is that the bills be read a third time. Those in favor? Against? Madam Clerk? Okay.
A bill entitled An Act to Establish a Contributory Pension Scheme for the Public Service to be known as the Public Service Pension Scheme, from which payment of pensions, gratuities, and other allowances are to be paid in respect of the service of pensionable officers, and to provide for other related matters. Read a third time and passed.
In relation to the second act, you'll recognize that we need to have a roll call and vote. Madam Clerk?
Oh, I'm taking the vote now. To move for third reading. Okay, taking the vote now. Senator Braham. This is that the bill be read a third time. This is the question. Third reading. Senator Braham. Senator Brown. Senator Brownberg. Senator Charles. Senator Fraser Binns. Senator Fraser Binns. Senator Gale. Senator Golding. Senator Hill. Senator Johnson Smith. Senator Knight. Senator Longmore. Senator Morris. Senator Morrison. Senator Reid. Senator Samuda. Senator Sinclair. Senator Skeffrey. Senator Slowly. Senator Webby. Senator Williams. Mr. President.
Thank you very much, Madam Clerk. I think you all deserve. Oh.
So then I just read the bill.
I do report the voting as follows: 17 ayes, 1 abstention, 3 absent. The ayes have it.
A bill entitled An Act to Amend the Constitution of Jamaica to provide for circumstances in which pensions, gratuities, and other allowances may be paid out of a fund established by law other than the Consolidated Fund, read a third time and passed.
It's intended to just do one more brief piece of business this afternoon, and this is to address a motion on the table in respect of the New Forest Duff House Irrigation Area Amendment Order 2016 and the New Forest Duff House Irrigation Area Amendment Order. Pardon me. I seem to. The resolution before us, Mr. President, is put forward because the irrigation area, which is to include the Essex Valley and Spring Ground areas, are now currently not included in the scope or in the remit of the National Irrigation Council. And of course, they are they're only authorized to act within gazetted irrigation boundaries. And the current gazetted irrigation boundary of New Forest does not permit them to so act. And there are farmers in these areas who are suffering. That is, that the NIC is by law prohibited from serving their needs. So the amendment order before us, Mr. President, which may be found at number 13 of the order papers, or page 7 of 13 on the order papers. May I take them as read? It is asked for that this motion be approved. No, pardon. It is. There are 2 resolutions in the motion. Pardon me.
Mr. President.
Senator Skeffrey, I haven't heard you all morning.
We on this side support the orders on the order paper. But I just want to say, we understand the critical importance of irrigation water to that side of the island. You know, the New Forest Duff House area is in South Manchester, and that's the constituency where I'm from, just up the hill in Cross Keys. And we understand the challenges the farmers face.
That's where you're from, or that's where you have a political interest?
No, I'm from, I was born and grown in Cross Keys. Yeah? So we understand the importance of, and to the south side of St. Elizabeth also, that whole Essex Valley area. We understand those farmers are excellent farmers. And sometimes you wonder how they produce the quality products, given the challenges with drought or on an annual basis. So any initiative, this initiative in the New Forest, the Forest area, and the agro parks was one that started under the previous administration and continue under this administration. And irrigation water is critical to the whole initiative and enhancing the production. I just want to ensure that while we broaden the area or the scope where we have this access from the National Irrigation Commission, that we really ensure we have the capacity to provide the source to the farmers on a consistent and or regular basis, so they can plan and organize their activities and be assured as to the reliability of the source. Also a critical problem, Mr. President, sometimes affecting the sources, the pumping capacity. We have the situation of pumps breakdown on a regular basis. So while the farmers, they tilt the soil, plan their reproductive activities, and prepare no rainfall, relying on this source, and the pumping facility breakdown for a long period of time, they will know the disadvantages that they are placed at. So while we broaden, so it's currently affecting the current area. So we don't want to seek to broaden the area and basically broaden the problem. So we want to ensure that we can give them reliability of source and the whole pumping facility as we move from. They have some underground wells in the area, right? So we want to ensure, so we're glad for this, and also to ensure also that at times we cater for the local farmers in the community. What tends to happen sometimes, and it's happening in those areas, which is, we don't have a fundamental problem, but some of those persons from outside the area, they lease the land in large parcels, and they are the ones that do the productivity. And sometimes the local farmers look on and don't benefit from the facility, and still have to wait on the drip irrigation, carrying the jump on to the farm and so on, while others reap a benefit that is in their own area. So if we can have a form of cooperation where both local farmers and those of a larger size outside integrate to enhance productivity. But we hope that this initiative will continue to benefit the farmer, add to the productivity of the country, and give us greater growth in the agricultural sector to enhance economic growth that is needed for our country as we move forward to development. So we support it on this side, and we hope it will achieve its objectives.
Thank you very much, Senator Skeff. So everybody, Senator Knight is asking if everybody from St. Elizabeth have to talk. Go ahead, please, Senator Hill.
Thank you, Mr. President. And I assure Senator Knight that not only am I from St. Elizabeth, which is why I stand, but more importantly, today I stand as the chairman of the National Irrigation Commission and the National Water Commission. We met yesterday as a board at the NIC, and in fact, the Essex Valley expansion of not just the area but the water capacity. I can assure you, Senator Skerfer, because I know it's very close to your heart, that we're spending, we're planning, we're organizing to expand so that the people in that drought-stricken area, very often drought-stricken area, now it's green and luscious because we've had rains, will be supported. I go here regularly, Senator Brown. Will be supported not only from the NIC, but also from the work that we're doing at the NWC. And we're going to continue because we see this as a very important part of economic growth. If our small farmers will benefit from the investment that taxpayers' money put in, and also we get grants from overseas. DFID and others have been very helpful with us. on this, and so we're very pleased about it, and pleased to report that the NIC, especially for irrigation, and NWC are taking steps to expand the air, not only the air in the Essex Valley, but the capacity to deliver water to people who really need it, and not just rich farmers from outside. Mr. President, thanks.
Thank you very much. The question is that this regulation be approved. Those in favor?
Aye.
Against?
Resolution.
Mr. President.
Okay. Mr. President, it is not intended to do any further business today. I want to thank colleagues for their participation, not only in today's debate, but in the work that led up to the passage of the two very important bills that we passed, and of course, no less so, the resolution which has just been approved. Mr. President, might the Senate be adjourned for a date to be fixed?
Thanks for the correction, Madam Leader. It was a resolution, not a regulation. So I thank you for that, Madam Leader. The question is that the Senate be adjourned for a date to be fixed. Those in favor? Against? The Senate now stands adjourned.
Come celebrate the journey of the Jamaica folk singers, the finest and most versatile choral singers in Jamaica on PBC Jamaica, Sunday, October 1 at 9 p.m. The Jamaican Folk Singers 50th Anniversary Concert showcased Jamaica's rich musical culture, including Me Coffee and other timeless Jamaican folk songs. Share the Jamaica Folk Singers' journey and passion for music right here on PBC Jamaica, Sunday, October 1 at 9 p.m.
Brand new series called with Sonia coming soon. I'll be speaking to influential guys that nothing is impossible. In the middle of your difficulty, you will find an opportunity. All of my guests use their opportunity to go out into the world and make a change in their community. They are leaders, industry experts, thought provokers, and champions. To be a game changer, you must know how to change your game. So I look forward to bringing you Visibility with Sonia.
It's Friday, September 29. This is the news on PBCJ. I'm Carol Francis. A U.S. $30 million integrated tech campus is to be built in Kingston by Stanley Motor Limited, a subsidiary of the Musson Group. The campus, to be located at 58 Halfway Tree Road in Kingston, will reportedly house business processing outsourcing companies. Associated services of the facility will include a daycare center, ATM and financial services, healthcare and food service companies. Stanley Motor has reportedly signed off on a lease arrangement with a BPO company, Alorica, which provides global service in the communications, financial, healthcare, hospitality, retail, and technology industry. Alorica employs 1,000 agents for its operations in Portmore St. Catherine. It plans to add another 5,000 employees for its new site in Kingston. Director of Elections Orette Fisher says the Electoral Commission of Jamaica, the EOJ, is concerned by reports that the Boundaries Committee of Parliament has rejected its recommendation on changes to certain constituency boundaries on the basis that they are erroneous. The recommendations were made following a review of constituency boundaries that were found to be in breach of the Constitution by the EOJ. On September 12, members of the Human Resource and Social Committee of Parliament rejected the realignment of boundaries report from the EOJ on the grounds of inaccurate, contradictory, and confusing information. Mr. Fisher defended the integrity and capacity of the EOJ staff in a letter to the committee and said he stands by the recommendations made in the report. The Director of Elections says while it is the sovereign right of the committee to reject its recommendations, he's uncomfortable with electoral boundaries being in breach of the Constitution. A 27-member shadow cabinet was unveiled by leader of the People's National Party, Dr. Peter Phillips. 2 non-parliamentarians were named to the shadow cabinet. They are Damon Crawford and attorney Donna Scott Motley. The 2 are reportedly expected to replace opposition senators Mark Golding and Angela Brown Burke in the Senate after the 2 contest the upcoming by-elections in St. Andrews South and St. Andrews Southwestern, respectively.
That we have tried in this particular composition of this new shadow cabinet to take account of 2 particular needs. First of all, the ability to provide an effective opposition in the parliament, and secondly, to give some signal as to the priority areas of emphasis of the People's National Party and of a potential future People's National Party administration.
Jamaica has jumped by 5 places in the latest Global Competitiveness Report, moving to 70th position compared to 75 last year. The decline shows a steady improvement since 2012, when Jamaica placed 97 out of 144 countries. The results of the 2018 report were published by the World Economic Forum on Wednesday. The report is created with input from various partner institutes in each of the listed countries. The Chinese embassy in Jamaica hosted a China National Day reception at the Jamaica Pegasus Hotel in New Kingston last night. In his address, China's ambassador to Jamaica spoke of the strengthened political mutual trust between Jamaica and China, as well as exchanges and cooperations on some important projects.
Economic cooperation is ever expanding. Cupid's Bridge in central Clarendon was completed. Marcus Garvey Avenue in Kingston was upgraded. Other works of significance in infrastructure will soon start. Chinese companies work hard to satisfy their Jamaican customers, government and private alike. They are hiring and training more Jamaican workers than ever. Our trade will be more balanced with Jamaican seafood exports starting soon. And Jamaican fishermen will have to work hard to satisfy China's demand for Jamaican lobsters. China continues to provide assistance wherever possible. Construction of the office building of the Foreign Ministry is proceeding as planned. Two kindergartens in Kingston and Morant Bay will hopefully be open to children in the next year. Preparation is underway for construction of the Western Children's Hospital to start next year. Our bilateral cooperation on human resources training is expanding faster than I expected. 500 plus of offers of short-term training in various fields have been taken this year, a big increase over last year's 260. Thank you. Sports and education. Minister Oliver Grange and I are working to have Chinese synchronized swimming and badminton coaches to come to Jamaica as a payback to Jamaica's generosity in training 10 Chinese coaches and students.
And in her address, Minister of Foreign Affairs Kamina Johnson-Smith said Jamaica highly values the enduring friendship and diplomatic relationship with China.
Today, our relations are vibrant and productive, having expanded significantly to include new areas of collaboration and cooperation, including infrastructure development, capacity building through scholarships and training, as well as institutional and technological support. This includes the acquisition of Alpart last year by GISCO, the new loan agreement for US $326 million with the Exim Bank of China for the Southern Coastal Highway Improvement Project, and the Western Children's Hospital Project, of course. The visit early this year by Vice Chairman of the NRDC, His Excellency Mr. Ning Xingzhu, also contributed to the strengthening of our bonds of cooperation, as evidenced by the signing of a production framework agreement on production capacity and investment during his visit. I am also pleased that earlier this year, we had the honor of hosting His Excellency Yang Shichu, State Councillor of the People's Republic of China, on his recent official visit to Jamaica.
Chinese National Day is celebrated on October 1 every year to commemorate the founding of the People's Republic of China. On that day, lots of large-scale activities are held nationwide. Besides, the 7-day holiday from October 1 to 7 is called the Golden Week, during which more and more Chinese people go traveling around the country and the world. Those in attendance at the Chinese National Day celebrations at the Jamaica Pegasus Hotel were treated to exciting, breathtaking new concept acrobatics, musical performances with a violin and zither, and magical performances by the Shenzhen Arts Troupe who came from China for the National Day event. And we go now to news from the region. International ratings agency Standards & Poor's S&P has raised a red flag that Barbados' long-standing 2-to-1 peg to the US dollar is under threat as economic conditions continue to deteriorate. In a report, S&P also warned that the Frundell-Stewart administration was unlikely to balance its budget anytime soon, given lingering challenges including poor implementation of policy decisions, the likely overestimation of one-off revenues, and approaching general elections. Against this backdrop, S&P lowered the island's long-term local currency sovereign credit rating to CCC from CCC+, while affirming its long-term foreign currency sovereign rating at CCC+. Over in Trinidad, the economy is reportedly said to be on a downward spiral. Prime Minister Dr. Keith Rowley says cuts in expenditure are unavoidable. He says government revenues has fallen by 90% over the last 3 years.
Looking at matters in terms of ease of doing business, competitiveness, looking at our foreign exchange reserves in particular, doing what is necessary to get the country to a point where we can start to rebuild our credit rating. In the meantime, we had said that what the country needed was the source of cheapest funds internationally so we could borrow to bolster our foreign reserves. There is no secret that one of the cheapest sources of foreign currency is the
time now for sports. Former politician and football official Austin Jack Warner has reportedly lost his lawsuit challenging his extradition to the United States. Mr. Warner is wanted by authorities to answer charges of fraud arising out of a FIFA bribery scandal. On Wednesday, Justice James Aboud dismissed the claim for judicial review brought by Mr. Warner. The lawsuit challenged the process used by the Office of the Attorney General in signing off on the U.S. government's request for his extradition in May 2015. It now means that the extradition proceedings in the Port of Spain Magistrates Court will resume. There is reportedly a 28-day stay on the extradition proceedings to give Mr. Warner time to consider whether he wants to appeal the decision. And that's our news and sports. Weather is next. And time now for a weather report and forecast. A high-pressure ridge is expected to remain across the island until tomorrow. Thereafter, a trough is expected to become the significant feature. This has resulted in partly cloudy conditions across eastern parishes. This afternoon, we can expect partly cloudy conditions with periods of isolated showers and thunderstorms, mainly across central and western parishes. Tonight, it will be partly cloudy. And time now for our extended weather report and a forecast, as well as our travel planner. And that's our weather report and forecast. Join us again next week, same time, same place, for more news, sports, weather, right here on PBCJ, the People's Station.
In Jamaica, there needs to be one law for all. Every member of this society, regardless of profession, finances,